Can I get custody even if the divorce was my fault? I'm Tulsa attorney James Worth. That's a question that we have as it relates to Oklahoma law. If the divorce is your fault, does that mean that you can't get custody? And the answer to that is no. It doesn't mean that. They're two completely separate issues. There could be some overlap there. I mean, ultimately, just because the court determines that you're at fault for the divorce, if the court makes that determination, the great majority, super majority of divorces in the state of Oklahoma are granted on the basis of irreconcilable differences, irreconcilable incompatibility, where no fault is determined. However, if the other side does allege fault, they could push that forward. And if the court does determine there was fault for the divorce, that does not automatically affect anything else in the case. Doesn't necessarily automatically affect spousal support or property division, custody, visitation, child support. Doesn't have an effect on any of those automatically. However, there are some faults where just because they meet the requirements there, it also may meet requirements elsewhere. Okay, so if there's been extreme cruelty and that's the grounds for divorce, well, maybe that's part of domestic violence. Well, if there's domestic violence, particularly if the kids have been subjected to it, then that creates certain presumptions related to custody that can go against you. But it's not the fact that the divorce was granted because of fault. It's the fact that there was domestic violence that the court determined existed and it affected the children. That's the difference there. Another one would be habitual drunkenness. That can be a ground for a fault divorce. The fact that a fault divorce is granted for that makes no difference on custody. But if the other side establishes that you've been drunk around the children and haven't been a good caregiver, well, then that is something the court's going to consider when determining the best interest as it relates to custody and visitation. So to answer the question, technically, it has no difference. To answer the question practically, it depends on what the underlying facts are and how those are presented and what the judge believes. If you've been a danger to the children and that danger you've been to children qualifies as both a danger to the children and a technical grounds for fault divorce, then it's going to be applicable. So hopefully that answers your question. But if not, talk to an attorney about your specific circumstances. Get legal advice personalized to you. To get that scheduled or to contact an attorney at my office to get that advice, go to makelaweasy.com.